Legal and Privacy Brief for March 21, 2026. Spanish e-commerce company Securic fined euros 1.9 million for database breach, affecting over 1 million records after failing to secure legacy systems and notify customers within 72 hours. UKICO. The Information Commissioner's Office fined Reddit £14.47 million for unlawfully processing children's data without parental consent and failing to conduct impact assessments. Congress preparing to extend Section 702 surveillance authority without warrant requirements despite documented abuses against protesters, lawmakers, and journalists. Here's the full breakdown of today's top legal and privacy stories. Legal and Privacy Brief, March 21, 2026. Next section, Enforcement Actions. Spanish D.P.A. Data Protection Authority fines e-commerce company euros 1.09 for database breach, PS/552/2023. Spain's Data Protection Authority, EPT, fines Securic Innovations euros 1,090,000 after a database containing over 1 million customer and employee records was offered for sale on the dark web in April 2023. The breach originated from a decommissioned e-commerce platform that remained accessible via the internet with outdated software. No monitoring, logging, or access controls. The controller delayed notification to EPT for 7 days after initial warnings from Spain's Cybersecurity Institute, INCIBE, and failed to inform data subjects for nearly 2 years. The EPT found violations of Article 5.1.f, Security Principle, Article 32, Security Measures, Article 33, Breach Notification within 72 hours, and Article 34, Data Subject Notification. The authority ruled that controllers cannot delay breach notification based on uncertainty about the scope of a breach and must act upon reasonable indications of compromise. Compliance action. Legacy systems that remain internet accessible must have security hardening equivalent to production systems. And notified of potential breaches by third parties, conduct internal investigations immediately, but do not delay regulatory notification beyond 72 hours while awaiting investigation results. Data subject notification is required when large volumes of personal data are involved and potential risks cannot be excluded. Source: GDP Rub PS/552/2023. UKICO. The Information Commissioner's Office fines Reddit £14.47 for processing children's data without parental consent. The UK Information Commissioner's Office fined Reddit Inc. £14,472,500, approximately euros 16.76 million, for unlawfully processing personal data of children under 13 years old between May 2018 and July 2025. Reddit had no age assurance mechanism during this period, only asking users to self-declare if they were over 18 without verification. For children under 13, Reddit failed to obtain consent from parents as required by Article 8 UKG DPR, the General Data Protection Regulation, for processing via advertising and analytics cookies. The ICO found Reddit violated Article 5.1.a, lawfulness, fairness, and transparency, because none of the legal bases under Article 6.1 applied to the processing. Reddit also failed to conduct any data protection impact assessment, DPIA, for processing children's personal data until January 2025, violating Article 35.1 UK GDPR. The platform hosts potentially harmful content accessible to minors. Compliance action. Online platforms targeting or accessible to users under 18 must implement age verification or age assurance mechanisms before processing personal data. For users under 13, obtain verifiable parental consent for any processing requiring consent as a legal basis. Conduct DPIA for any processing of children's personal data, especially in the context of online services. Review platform content moderation for child safety risks. Source: GDP Rub Reddit Inc. FBI seizes infrastructure from 4 botnets with 3 million compromised devices. The U.S. Department of Justice seized domains and virtual servers used by the Asaru, Kim Wolf, Jackskid, and Mossad botnets, which compromised approximately 3 million EOT devices worldwide, including hundreds of thousands in the United States. The botnets targeted cameras, routers, video recorders, and devices behind firewalls, selling access to cybercriminals for DDoS attacks and criminal activity masking. The botnets issued more than 316,000 DDoS attack commands combined, causing victims hundreds of thousands of dollars in remediation expenses and ransom demands. The Kimwolf botnet used a novel technique to infiltrate residential proxy networks through compromised home devices like streaming TV boxes, gaining access to local networks typically protected by home routers. Law enforcement in the U.S. Germany and Canada coordinated the disruption with support from Amazon and other tech companies. The Department of Defense Information Network, DoDIN, was among the targets. Compliance action. EOT devices must have security hardening before deployment, including disabling default credentials, enabling automatic security updates, and network segmentation. Home routers protecting EOT devices require firmware updates and strong authentication. Organizations should monitor for unusual outbound traffic from EOT devices that could indicate botnet compromise. Source: The Record. FBI takes down Iranian Moaz leak sites used in multi-year campaign. The FBI seized 4 domains, Justice Homeland. Org Handala hack. 2 Carmeblo 80. Org Handala Red Wanted. 2 used by Iran's Ministry of Intelligence and Security, Moaz, to host stolen data from Albania, Israeli government officials, Iranian dissidents and U.S. companies dating back to 2022. The group, operating as Handala, conducted attacks on Albania's government in July and September 2022, disrupting passport systems and cross-referencing databases. In March 2026, Handala attacked Michigan-based medical technology company Stryker, using Microsoft Intune's native device wipe feature to destroy data on over 200,000 devices across the U.S., Ireland, and India. The attack directly impacted emergency medical services and hospitals in Maryland, forcing clinicians to rely on radio communication instead of hands-free devices. Handala posted 851 gigabytes of data, allegedly stolen from the Sanzer Hasidic Jewish community, and sent threatening emails to Israeli Defense Force officials. The FBI issued guidance to Microsoft Intune users about the device wipe feature abuse. Compliance action. Microsoft Intune administrators should implement additional authentication controls for remote device wipe features and enable alerts for bulk wipe operations. Critical healthcare IT systems should have backup communication channels that do not depend on internet-connected devices. Review conditional access policies to restrict device management functions to trusted locations and devices. Source: The Record. Next section, Litigation Updates. Essen Medical Associates $4 data breach settlement, Rivera v. Essen Medical Associates case no. 801,239/2024 Essen Medical Associates agreed to a $4 million class action settlement for a March 2023 data breach that compromised patient social security numbers and health insurance data. Plaintiffs alleged the New York healthcare provider failed to implement reasonable cybersecurity measures and did not timely notify patients, preventing them from taking prompt steps to protect against fraud or identity theft. The settlement provides up to $5,000 in reimbursement for documented losses, including unreimbursed fraudulent charges, identity theft expenses, and credit monitoring costs. Class members can also receive a $100 cash payment, subject to pro rata reduction. The claims deadline is June 1, 2026, with final approval scheduled for July 7, 2026 in the Supreme Court of the State of New York, Bronx County. Compliance action. Healthcare providers should document cybersecurity investment and incident response timelines to defend against breach litigation. Breach notification timing is a litigation risk factor. Notify patients within days of confirming a breach, not weeks. Budget for potential settlement costs when calculating breach risk using recent healthcare settlements as benchmarks. Source: Top class actions. UPS and FedEx face class actions over unlawful tariff charges following Supreme Court ruling. United Parcel Service and Federal Express Corporation face separate class actions alleging they collected tariff charges declared illegal by the Supreme Court on February 20, 2026. The court ruled certain tariffs imposed under the International Emergency Economic Powers Act, IEEPA, were unlawful. Plaintiff Holly Anastopoulos filed the UPS case no. 1-26 CV 1005, ND. Georgia, alleging UPS collected unlawful tariff charges from customers and was unjustly enriched by retaining charges derived from invalid tariffs. Plaintiff Matthew Reiser filed the FedEx case no. 1-26 CV 21328, SD. Florida, alleging FedEx unlawfully charged import duties on products classified as duty-free under the Harmonized Tariff Schedule of the United States, HSUS, with a Column 1 general duty rate of free. Reiser claims FedEx also charged ancillary brokerage and clearance fees for customs processing that would not have been required for duty-free products. FedEx filed its own lawsuit seeking a refund from the United States, but has not committed to returning refunds to consumers who originally paid the duties. Compliance action. Companies that collected IEEPA-based tariff surcharges should review contracts for refund obligations and assess exposure to unjust enrichment claims. Consider proactive customer refunds to mitigate class action risk. Review tariff billing systems to remove invalidated surcharges and prepare documentation of tariff compliance for regulatory inquiries. Sources: Top Class Actions, UPS, Top Class Actions, FedEx. Uber Class Action alleges misleading arrival time estimates. YV, Uber Technologies Case No. 3-26 CV 1744. Lucy E. filed a class action in California federal court on February 27, 2026, alleging Uber Technologies misleads consumers about rideshare arrival times. The lawsuit claims Uber advertises precise arrival times like 3 min for its Uber X option, which is often preselected and labeled faster than alternatives like Wait and Save, but frequently fails to deliver on this promise. He alleges Uber's misrepresentation is not accidental, but a calculated move to extract a price premium by tailoring arrival times and prices to make certain options appear faster even when they are not. The lawsuit claims Uber provides no disclaimer about the imprecision of arrival times and does not offer refunds for late arrivals. He seeks to represent anyone in the United States who paid for a ride advertised as faster or with a specific arrival time, but were not picked up within the advertised time. The case alleges violations of California's unfair competition law, false advertising law, Consumers Legal Remedies Act, and claims for unjust enrichment and fraud. Source: Top Class Actions. Supreme Court allows street preachers' free speech case to proceed. Olivier v. City of Brandon. The Supreme Court unanimously ruled that Gabriel Olivier's lawsuit seeking to block future enforcement of Brandon, Mississippi's public demonstration ordinance can proceed despite his prior conviction for violating the same ordinance. Justice Alina Kagan wrote that a lawsuit seeking purely prospective remedy is not barred by Heck v. Humphrey, which limits challenges convicted criminals can bring against the law under which they were convicted. Olivier, a public evangelist, was arrested in May 2021 and fined $304 after leaving a designated protest area at an amphitheater to get closer to crowds. He pleaded no contest and later challenged the ordinance as a violation of his First Amendment right to free speech. The Fifth Circuit had ruled his lawsuit could not proceed under Heck, but the Supreme Court reversed, stating the lawsuit is future-oriented even if success would show his prior conviction should not have occurred. The court held that forcing Olivier to choose between risking another prosecution or foregoing constitutionally protected speech is untenable. Source: Scadu S. blog. Fifth Circuit lifts injunction against Louisiana 10 Commandments law. The Fifth Circuit Court of Appeals reversed its June 2025 ruling and lifted the injunction preventing Louisiana's law mandating 10 Commandments displays in public schools from taking effect. The en banc opinion released in late February 2026 concludes the lawsuit is premature because the court does not know how the mandate will look in practice. Louisiana law HB 71 sets minimum requirements for text, size, and a context statement, but delegates the nature of displays to local school boards, leaving questions about prominence, accompanying materials, and teacher references unanswered. The court's June 2025 panel opinion had ruled the law violated the Constitution by elevating one particular religion with government backing, and laid bare the pretext of calling 10 Commandments displays optional when they must be posted prominently, while other foundational documents need not be visible. The new en banc opinion permits the law to take effect despite prior rulings from other courts, including the U.S. Supreme Court, declaring similar laws unconstitutional violations of church-state separation. Source: TechDirt. Supreme Court to hear arbitration exemption case for last-mile drivers, Flowers Foods v. Brock. The Supreme Court will consider whether last-mile drivers who deliver from regional warehouses to stores are exempt from the Federal Arbitration Act's arbitration requirements. Angelo Brock delivers baked goods for Flowers Foods exclusively within Colorado after products are shipped across state lines to a local warehouse. The case turns on whether Brock's wholly intrastate employment on one leg of an interstate transaction makes him a worker engaged in interstate commerce under the FAA's transportation worker exemption. Flowers Foods argues the key question is the work employees perform, not the commerce to which it relates, because Brock has no direct role in cross-border transportation. Brock argues he is a transportation worker handling shipments that travel in interstate commerce. The decision will affect whether last-mile delivery workers can be forced into arbitration when they have disputes with employers. Oral arguments are scheduled for April. Source: Scadu S. blog. Man pleads guilty to $8 AI-generated music streaming fraud. Michael Smith, 54, of North Carolina, pleaded guilty to orchestrating a music streaming fraud scheme using artificial intelligence and bot accounts to siphon more than $8 million in royalties between 2017 and 2024. Smith worked with a co-conspirator and an AI music company CEO to acquire a catalog of computer-generated tracks, uploading them to Amazon Music, Apple Music, Spotify, and YouTube Music. It used automated software to direct up to 10,000 bot accounts to continuously play the songs, generating billions of streams. To avoid detection, activity was spread across thousands of tracks and routed through VPNs to mimic legitimate listeners. Smith created fake email addresses in bulk and outsourced labor to register accounts. Prosecutors said the $8 million would otherwise have gone to legitimate artists and songwriters. Smith faces up to 5 years in prison. Streaming platforms prohibit artificial inflation of play counts through bots. Compliance action. Streaming platforms should implement bot detection for account creation patterns, unusual listening behavior, continuous playback without user interaction, and VPN routing anomalies. Track upload volume and cross-reference against known AI-generated music characteristics. Consider requiring verified artist identity for royalty payments above certain thresholds. Source: The Record. Next section, regulatory guidance. Fifth Circuit issues Birthright Citizenship live blog notice, Trump v. Barbara Scotto S. blog announced it will live blog oral arguments on April 1, 2026 for Trump v. Barbara concerning the constitutionality of President Donald Trump's executive order on birthright citizenship. No substantive ruling or guidance has been issued yet, but the case challenges executive authority to redefine citizenship under the 14th Amendment. The oral arguments will be available via live blog without login required. Source: Scotto S. blog. Next section, privacy developments. Proton Mail shared user metadata with Swiss authorities. Passed to FBI 404 media reported Proton Mail provided subscriber metadata to the Swiss government, which passed the information to the FBI. The data included payment information related to a particular account rather than message content, but demonstrates that privacy-centric email services are subject to lawful requests from authorities in their jurisdictions. Security researcher Bruce Schneier noted this sort of information sharing happens even to companies focused on privacy, and users should understand the limitations of privacy protections when law enforcement presents valid legal process. Compliance action. Privacy-focused services should document in privacy policies the specific types of data subject to government requests and the jurisdictional authorities with legal process powers. Metadata including payment information, IP addresses, and account recovery data is typically not covered by end-to-end encryption and may be subject to disclosure. Transparency reports should specify the volume and types of law enforcement requests received and fulfilled. Source: Schneier on security. Minnesota Age Verification Bill threatens LGBTQ youth access to information. Minnesota House Bill 1434 would require websites hosting speech protected by the First Amendment for both adults and young people to verify users' identities through government ID or biometric data. The bill's definition of speech harmful to minors is broad enough to include lawful content about sexual orientation, sexual health, and gender identity. Rep. Lee Fink testified that age verification laws are already being used to block LGBTQ youth from accessing educational, affirming, or life-saving information, referencing Free Speech Coalition v. Paxton, in which state attorneys general demonstrated eagerness to use these laws to restrict queer youth. The Texas law upheld in FSC v. Paxton requires age verification for sites where at least 1/3 of content is sexual material deemed harmful to minors. But Minnesota HF 1434 expands what the state deems harmful beyond sexual content. Critics argue the law violates adults and young people's First Amendment rights by preventing community access online and jeopardizing data security and privacy through mandatory identity verification. Compliance action. Websites offering sexual health information, LGBTQ resources, or content that could be interpreted as related to prurient interest should monitor state age verification bills and prepare for compliance costs including identity verification systems or geofencing. Consider First Amendment litigation risk if restricting access to lawful educational content. Review privacy policies for biometric data collection and retention requirements under state laws. Source: TechDirt. Australia's teen social media ban shows widespread circumvention after 3 months' data from parental monitoring company Qustodio shows that the majority of Australian teens aged 10-15 who use TikTok, YouTube, and Snapchat before the under-16 social media ban remained on the services afterward. The usage drop was only marginally larger than the normal seasonal decline that occurs annually when summer ends. The Courier Mail reported similar findings. Critics warned the ban would harm vulnerable children, particularly those with disabilities who lost critical support communities, while tech-savvy teens easily bypass the restrictions. The ban selected for vulnerability by blocking isolated children and those lacking technical skills while teaching the majority of teens to route around age verification systems. The result is a false sense of security among adults and eliminated political pressure to fund digital literacy programs. Source: TechDirt. H&R Block tax software installs TLS backdoor with included private key. H&R Block Business 2025 tax software installs a root certificate authority named WKATX Server Host 2024, expiry 2049, into the local machine trusted root certificate store and includes the private key in a D.L.L. dynamic link library file. A certificate does not identify itself as H&R Block and is not removed when the software is uninstalled. Security researchers successfully used the root CA with Mint proxy to manipulate TLS traffic on a virtual machine on the same network using a DNS spoofing attack. This backdoor allows anyone with access to the included private key to intercept encrypted communications from systems with the software installed. H&R Block has not addressed or fixed the issue. The vulnerability affects U.S. taxpayers worldwide who use the software during tax season. Compliance action. Do not install H&R Block Business 2025 on systems handling confidential client data or personal information. If already installed, remove the WKATX Server Host 2024 root certificate from the Trusted Root Certification Authorities store using Certger. MSC. Organizations should inventory all installed root certificates and investigate any certificates with long expiry dates, 2040 plus, that do not identify the software publisher. Consider using two systems with an air gap, one for private work never connected to networks, one for external communications never used for private data. Source: Schneier on security. Next section, policy changes. Congress prepares clean extension of Section 702, surveillance without reform. House Speaker Mike Johnson confirmed plans to pass a clean 18-month extension of Section 702 of the Foreign Intelligence Surveillance Act, FISA, without reforms. Section 702 allows the federal government to collect electronic communications of foreigners abroad without a warrant. The 2024 Reforming Intelligence and Securing America Act, RISA, extended Section 702 for only 2 years to allow negotiation of a warrant requirement for Americans and other reforms, but Congress did not continue this work. Section 702 will sunset on April 20, 2026, without action. House Judiciary Chair Jim Jordan, previously a champion of warrant requirements and closing the data broker loophole, said he would vote for a clean extension, claiming RISA included enough reforms. Section 702 was previously misused for improper queries on peaceful protesters, federal and state lawmakers, congressional staff, thousands of campaign donors, journalists, and a judge reporting civil rights violations. RISA expanded government authority to compel a larger group of people and providers into assisting with surveillance. 3 reform bills are available, SAFE, PLUSA, GSRA, but are not being considered. The extension vote is expected the week of April 14, 2026. Compliance action. Service providers potentially subject to Section 702 compulsion should review RISA expansion of electronic communication service provider definition and assess whether they may be compelled to assist with surveillance. Prepare for potential national security letters or FISA orders. Transparency report templates should account for Section 702 orders if previously exempt. Consult counsel on gag order compliance when receiving surveillance demands. Source: EFF. Rep. LaHood supports Section 702 extension without warrant requirement. Rep. Darren LaHood, RRIL, chair of the House Intelligence Committee's NSA subcommittee and member of the FISA working group, supports President Trump's plan for an 18-month clean reauthorization of Section 702. LaHood stated he would prefer a 10-year extension and is glad that there is not a warrant requirement. He emphasized Section 702 is the singular most important collection item we have in our intelligence portfolio, and cited 56 reforms implemented through the 2024 Reforming Intelligence and Securing America Act. LaHood said the reforms should continue to be implemented, and this is not the time to let the program go dark. He advocated for the extension in questioning nations' top intelligence officials during the House Intelligence Committee's Worldwide Threats hearing. FBI searches of the Section 702 database rose approximately 35% from the previous year, according to recent reports. LaHood said the reforms are working to hold the FBI accountable. Source: The Record. FCC Chair Brendan Carr threatens broadcasters over unflattering coverage. EFF and other digital rights organizations called out FCC Chair Brendan Carr for unconstitutional threats to punish broadcasters for airing statements he disagrees with. Carr claimed the FCC's public interest standard allows him to revoke licenses of broadcasters who publish news unflattering to the government. The First Amendment constrains the FCC's authority to force broadcasters to align with government viewpoints, even though broadcast licensees must operate in the public interest, convenience, and necessity. Viewpoint-based restrictions on licensees' speech are subject to First Amendment scrutiny. The public interest requirement has never been interpreted to allow viewpoint-based punishment. Carr's allegations of falsity are a proxy for retaliation based on policy disagreements, criticism of the Trump administration, and treatment of information that contradicts the official U.S. government line about the Iran war. Civil society groups demanded Carr withdraw the threats. Compliance action. Broadcast licensees should document editorial independence and news judgment processes to defend against politically motivated license challenges. Review FCC license renewal applications for potential retaliation risk based on coverage decisions. Consult First Amendment counsel before altering news coverage in response to government pressure. Consider public transparency about government pressure attempts to create litigation record. Source: EFF. FCC Chair Carr plans patriotic call center answering requirement. FCC Chair Brendan Carr circulated plans to restrict U.S. telecom companies' use of foreign call centers and require foreign-based customer service workers to be proficient in American Standard English. Carr claimed the plan addresses cultural and language barriers that prevent Americans from resolving issues and protects consumers' personal information from foreign customer service centers. Critics argue there is no evidence overseas customer service centers create serious cybersecurity issues, and that Carr is using cybersecurity as a bogeyman for an unpopular industry-friendly plan. The plan may provide cover for telecom layoffs caused by industry consolidation that Carr has rubber-stamped. It is unclear whether the FCC has authority for this micromanagement of telecom support, which runs contrary to Carr's light regulatory touch rhetoric. Charter and other telecoms already have mostly U.S. support agents. Critics note Carr does not pursue policies inherently in the public interest and is likely working an angle for telecom industry giants. Source: TechDirt. Next section, compliance takeaways. Breach notification timing. Notify data protection authorities within 72 hours of reasonable indications of a breach under GDPR Article 33, even if investigation is ongoing. The Spanish Secodec case demonstrates that uncertainty about breach scope is not grounds for delay. Data subject notification under Article 34 is required when large volumes of data are involved and risks cannot be excluded. Legacy system security. Decommissioned systems that remain internet accessible must have security hardening equivalent to production environments. The Secodec Euros 1.9 million fine demonstrates that controllers are liable for breaches from legacy systems, lacking monitoring, logging, access controls, and updated software. Children's privacy compliance. Online platforms accessible to minors must implement age verification mechanisms and conduct DPIA before processing children's data. For users under 13, obtain verifiable parental consent for processing requiring consent as a legal basis, as demonstrated by Reddit's £14.47 million UK ICO fine. Section 702 Surveillance exposure. Service providers should prepare for potential Section 702 compulsion under RISA expanded definition of electronic communication service provider. The 18-month clean extension, expected by April 20, 2026, will not include warrant requirements despite documented abuses. Review transparency reporting obligations and legal counsel procedures for national security letters. H&R Block TLS backdoor mitigation. Remove WKATX server host 2024 root certificate from systems with H&R Block Business 2025 installed. Organizations should audit all installed root certificates and investigate certificates with unusually long expiry dates that do not clearly identify the software publisher. Implement air-gapped systems for sensitive tax and financial data processing. That concludes today's legal and privacy brief. From Carolina Clear Tech, for informational purposes only, not legal advice.